All right, today we're pulling back the curtain on legal problem solving. We're going to see how legal pros take a really complex mess of facts and turn it into a clear, solid case. Let's dive in. You know that feeling, right? When you're just completely stuck on a problem and you don't even know where to begin? We have all been there. Well, in the legal world, that exact feeling is pretty much the starting line for everything. It's what kicks off the whole process.
So, before we even slap the word legal on it, let's talk about what research really is. It's not just scrolling through Google hoping for the best. No, it's a methodical hunt for answers. It's organized, it's systematic, and it's all about moving from total confusion to real clarity. Think of it like building a foundation of facts, brick by brick, until the truth starts to take shape.
Okay, to make this feel real, let's walk through an example. Just picture it. You're cruising through the park on an e-scooter, minding your own business, and bam, a ticket for breaking a rule you had no idea even existed. It feels totally unfair. So, what do you do now?
See, that ticket, it's more than just a piece of paper. It's a legal puzzle. And the good news is, every puzzle has a solution. Your first move isn't to get mad. It's to start investigating. And in the legal world, we call that investigation legal research. At its heart, it's all about solving the problem. So how does this whole legal detective thing actually start? Well, there are two main paths you can take. Think of it as hitting the books versus hitting the streets. It's kind of like the difference between a quiet librarian digging through archives and a field investigator out there on the beat. Both are looking for clues, they just find them in very different places. Okay, so let's break that down. On one side, you've got pure legal research. This is hitting the books. For our e-scooter ticket, this means you'd be digging up the exact city ordinance, finding old court cases about park rules, and really trying to understand the legal ideas of fairness. But then you've got socio-legal research. This is hitting the streets. This is the law in action. Here, you'd be looking at whether this ban is enforced unfairly, or maybe how it's hurting commuters who actually need those scooters. So one approach looks at the rule itself, the other looks at its real-world consequences. All right, so you're out there, digging for clues. But how do you know if the clues you find are any good? I mean, you can't build a solid case on shaky ground, right? There are rules to this game, and they're often called the 4 C's. They're what makes sure your investigation is solid, reliable, and actually, works. And here's the deal. Your research has to tick every single one of these boxes. It has to be correct. You can't misread the law. It's got to be comprehensive. Missing just one little piece of evidence could sink your whole case. It absolutely needs to be credible. Your sources have to be trustworthy. And finally, it has to be cost-effective. Because let's be real, time and money aren't unlimited. This is the bedrock of any strong legal argument.
But finding all the right information, that's really only half the battle. Because if you can't communicate what you found clearly, all that great research is pretty much worthless. This is where we switch gears, moving from investigation to presentation, from legal research to legal writing.
Wow. This quote really says it all, doesn't it? In law, words aren't just words. They are scalpels. One wrong word, one fuzzy phrase, and you can completely butcher a case. The real skill isn't just knowing the law. It's being able to use its language with absolute surgical precision. And just like research, legal writing isn't a one-size-fits-all kind of thing. The biggest difference? It's the audience. So pure legal writing is that super technical language spoken between lawyers and judges. It's dense, precise, full of jargon like what you'd find in a will or a contract. But paralegal writing is for the rest of us. It's about explaining legal ideas in plain English, like you'd read in a news article about a new law. It's the same topic, just spoken in a different dialect so everyone can understand. So, when it's all said and done, what's the final verdict on legal writing? Well, for centuries, legal language has been famous for being, impossible to understand. But the modern goal, the absolute gold standard today, is the exact opposite: total and complete clarity. The whole point is to take this tangled mess of legal jargon and boil it down to a single, clear idea. And this isn't about dumbing it down at all. In fact, true mastery is taking something incredibly complex and making it seem simple. The goal isn't to sound smart by being confusing. The goal is to communicate. Great legal writing just cuts right through the noise. And why does this matter so much? Because clear writing is efficient writing. A document that's easy to understand saves time and money for everybody: the clients, the lawyers, the judges. It stops those expensive mistakes that happen because of a simple misunderstanding. In a system that can be slow and costly, clarity is one of the best tools for just making things work better. And all of this leaves us with a really big question. We're often told that law is the language of justice. But if that language is so complicated that only a tiny group of people can actually speak it, who is it really serving? The big push for plain language in law isn't just about style. It's about access to justice itself. And that's something we're thinking about.